A very good morning to all my dear students. Today we are going to discuss about the drafting of an application for bail under section 437 of the Code of Criminal Procedure 1973 under the subject captioned as drafting, pleading and convincing. My dear students, as you all are aware that for drafting a document, we must have to go through the procedure laid down under the procedural law. As far as the bail is concerned, it would fall under the category of or under the subject of Code of Criminal Procedure. As such, before starting to draft an application for bail, we must recapitulate the law laid down regarding it as provided under the Code of Criminal Procedure. My dear students, as such, we have to define what is the meaning of bail. As you all are aware that there is no definition of bail in the code, although the terms bailable offense and non-bailable offense have been defined under section 2A of the Code of Criminal Procedure. As per the definition given in the law lexicon, the word bail has been defined, and it is defined as security for the appearance of the accused person on giving which he is released pending trial or investigation. So my dear students, from this, what is contemplated by bail is to procure the release of a person from legal custody by undertaking that he shall appear at the time and place designated and submit himself to the jurisdiction and the judgment of the court. This was so held in the case of Motiram versus State of Madhya Pradesh, 1978, 4 SCC, page number 47. The Supreme Court has held that the bail covers both release on one's own bond with or without sureties. This was so held in the case of Motiram versus State of MP. Further, my dear students, the code has classified all offences into bailable and non-bailable offences, meaning thereby the Code of Criminal Procedure 1973 provides or classified all the offences into two categories, and these two categories are bailable and non-bailable offences. According to section 2A, bailable offence means an offence which is shown as bailable in the first schedule or which is made bailable by any other law for the time being in force. And non-bailable offence means any other offence. Meaning thereby, if a person accused of a bailable offence is arrested or detained without warrant, he has a right to be released on a bail. But if the offense is non-bailable, that does not mean that the person accused of such offense shall not be released on bail. But here in such a case, bail is not demanded or given as a matter of right, but only a privilege to be granted at the discretion of the court. So, as far as the application for bail under section 437 is concerned, it provides the ground or circumstances to be considered by the court in case of non-bailable offences. My dear students, whenever an accused is arrested and detained in custody by the police during investigation, and it appears that the investigation cannot be completed within 24 hours as fixed by section 157, the accused person must be forwarded to a judicial magistrate and the right to entitlement conferred to be released on bail after a stipulated time period as mentioned under section 167 clause 2 must be considered to be an absolute right subject of course to the cancellation of the bail if the requirements of 437 clause 5 are satisfied. Further, the object of this provision, that is 167, which has to be read with section 437 clause 2, is that the object of this provision is to put pressure on the investigating agency to complete the investigation expeditiously and within a reasonable time. Further, my dear students, as you all are aware that section 437 provides discretion in granting bail regarding the non-bailable offences. But how this discretion has to be applied or used by the court of law. So in this regard, it is submitted that when any person accused of or suspected of the commission of any non-bailable offence is arrested or detained without warrant by an officer in charge of a police station, or appears or is brought before a court other than the High Court or the Court of Session, he may be released on bail 437 clause 1. So this is provided under section 437 clause 1. The word may in the above provision clearly indicates that the police officer or the court has got discretion in granting bail. However, there are certain principles which should guide the police officers and the courts in the exercise of this discretion. And now, my dear students, what are the grounds or what are the considerations or the guidelines to be kept in mind by the court while granting a bail to an accused for non-bailable offence? These are enormity of the charge. Number 2, nature of the accusation. Number 3, severity of the offence which the conviction will entail. Number 4, nature of evidence in support of the accusation. Number 5, opportunity to the applicant for preparation of his defense and access to his counsel. Health, age and sex of the accused. Nature and gravity of the circumstances in which the offence is committed. Position and status of the accused with reference to the victim and witnesses. and the probability of the accused committing more offences if released on bail. So my dear students, these are certain considerations to be mentioned or to be kept in mind by a law student or by a lawyer while drafting a bail application. So my dear students, let's come to with this background, I hope I would be able to make you understand better about this topic, today's topic, that is application for bail under section 437 CRPC. Now let's start with the same. Now I would provide you the format for bail. As you all are aware that any application or any petition which is filed before the court of law must bear the court's name and designation of the judge. As such, the bail application has to be started with the same intent and same expression, and the same would be written as under. In the Court of Metropolitan Magistrate Dwarka Courts, New Delhi. This is one of the sample I am hereby provide it to you. As you all are aware that under section 57 CRPC and contemplated under section 167 also, that an accused must be produced after the arrest and within 24 hours he has to be produced before the concerned magistrate. So as such, the first application for the bail may lie to the Metropolitan Magistrate. As such, Metropolitan Magistrates or the Judicial Magistrate as the case may be. And thereafter you have to give the name of the place where this matter would fall. So here I am giving an example of the matter of the case which would fall in the category of which would fall in the jurisdiction of Dwarka courts. Thereafter you may mention like bail application number or criminal miscellaneous application number as the case may be. If it is an FIR, then you may mention the FIR number of so and so year. If it's not an FIR number, if it's only a criminal complaint number, then you may mention criminal complaint number instead of FIR number. As you all are aware that the criminal matter started or the prosecuted by the state, as such, the state would be the complainant in this case. State versus A, Mr. A, son of Mr. So-and-so, residence of so-and-so, may be an accused in this case. Next, you may have to mention the FIR number over here again, police station. Like Uttam Nagar police station falls in the category or Dwarka police station as the case may be. And under section, you have to mention the sentencing section over here. For example, in the case of theft is defined in section 378, but the punishment is given in section 379 IPC. So my dear students, while putting that section, you have to mention the punishing section. So you have to mention 379 IPC instead of 378 IPC. Next, you have to give title to the case. So here is the title to the application is that application for bail and under section 437. If it's a case of a bailable offense, then you may mention 436 CRPC, but right now it's a non-bailable offense bail. You have to mention 437. Thereafter, you may write it like that. It is most respectfully showed before this honorable court. Number one. Thereafter, you have to give the circumstances or the facts like this in the bail application that the accused is a permanent resident of so and so place in Dwarka and is living with his family from the last 20 years in that society. You may introduce the accused to the court of law. Thereafter, on whose complaint the FIR has been taken on record, in which police station and on what date and on which date. So this is the next step. You have to apprise about the complainant also to the court of law. Next, my dear students, that the police alleged that the applicant has kidnapped complainant daughter as she was nowhere to be seen in the society. So this is a case of kidnapping of the complainant daughter by the accused. So it's an alleging. Now in this, the complainant has alleged that his daughter has been kidnapped by Mr. A. Next, that the applicant is in the custody of the police from so and so date. Because, my dear student, why this particular fact needs to be mentioned? Because if the charge sheet is not filed within the stipulated time period, as the case may be, as provided in the section 167 clause 2 CRPC, then after the completion of the stipulated period, the court would grant him a bail, and that bail is known as default bail. That the applicant is in the custody of the police from so and so day, as it is a cognizable offense. Further, my dear student, as you all are aware that FIR is to be recorded with respect to cognizable offenses and not so non-cognizable offenses. What is a cognizable offense? Cognizable offenses are those offenses in which a police officer can arrest and can investigate a case without the permission of the concerned magistrate, whereas it is not so in the case of non-cognizable offenses. Further, the application for bail must also mention that the case filed or the FIR filed is false, bogus, and the applicant has been falsely implicated in the matter, as the facts of the case are fabricated by the police authorities or by the complainant, as the case may be. So, my dear student, you have to put the circumstances wherein you allege that the allegation put forth by the police authorities are false and bogus. Next, that there lies no reason for the investigation, custodial interrogation, and recovery from the accused. So, you may put like that before the court, meaning thereby that there is no need of putting the accused behind bars, as he is not needed for investigation or custodial interrogation, and as such there is no need for recovery, as such there is no recovery to be made from the accused. So this is also one of the circumstances on the basis of which the court may set the accused at liberty. Next, that the applicant is a permanent resident of India and will not abscond the boundaries of India. This is also one of the facts which will mention in the application, because if the accused would have abscond from the premises of the court or within the jurisdiction of the court, then it may be a circumstance for cancellation of bail also. Further, you may support the accused case by putting like that the applicant has no prior criminal record and belongs to a good family. Next, that the applicant will be present in the court when the court directs him to do so. So you will undertake before the court of law that he would be present on the date as and when called by the court of law in that particular criminal case, or if needed by the police authority as well. Next, that the applicant is ready and willing to accept the conditions and they ready to pay the surety amount as the court may deem fit. So my dear student, you may put or you may put before the court that he is ready to accept and ready to pay the surety amount as the court may deem fit. Now in the end, you may pray before the Honorable Court that it is most respectfully prayed before this Honorable Court to pass an order and allowing the bail application of the applicant or to pass any other order which this Honorable Court may deem fit in the present case and in the light of the present facts and circumstances. Thereafter, the application needs to be signed by the applicant and it must be recognized by the council also. So applicant and council may put their signatures on the last level. So this is all about the drafting of a bail application under section 437 CRPC. Hope you have learned a lot from this lecture. In case of doubt, you may write it to me at my email ID, that is rahul.gn@jagannath.org. But before parting with today's topic, I just want to apprise you with my new topic, which I am going to take in my next lecture. And my next lecture would be on the drafting of an application under section 125 CRPC. Till then, stay home, stay safe, and stay healthy. We'll meet you soon in my next lecture. Thank you very much.